Welcome to the Capitalist Corner. I'm your co-host, Michael Liebowitz. I'm also the vice chairman of the American Capitalist Party. Mark looks a little different today. He's in a different outfit. That actually, of course, is the wonderful James Valliant, Jim, as we can call him. Let me switch over to this. Okay. We've got a great show today. We're going to cover a lot of stuff, but remember, share from YouTube to your social media. And remember to check us out at AmericanCapitalistParty.org and check out my podcast as well, The Rational Egoist, and Jim will give you his info at the end. So, Jim, the first thing that I kind of want to talk to you about is this article that was actually, full disclosure, written by my producer, Xenia Awanu. She is relatively new to Objectivism. I believe she's currently enrolled in the Ayn Rand University. And she wrote what I thought was a pretty good article on individual rights. And as the American Capitalist Party is the party of individual rights, and as I have an expert on the subject on the show today, I figured we'd merge them all together. And you can tell us, first of all, about rights, what you think of the article.
I thought this was really an outstanding piece. I have to take my hat off to her. She did really an excellent job of covering what rights really are, what they're not, what they are, what their factual basis is, in really clear, lucid, really accessible language too. You know, she's, as far as I'm concerned, she outdoes me in terms of being able to give an understandable presentation of the correct theory of rights. So what can I say? She knocked it out of the park. I highly recommend. I hope there's a link in.
I just posted it to X, and while you're yapping, I'm going to post it to Facebook as well.
Yeah, well, I would love to be able to bust your balls on something, but this is exactly the opposite. She's an extremely lucid writer, very powerful presentation. I really like the way she treated it from the different angles which she treated it, and the language she uses is so understandable, so accessible that real people can understand it. I hate that word common sense. But if it has any real meaningful application, she explains it in such common sense language that really, I think anyone can grasp the objectivist concept of rights. I don't know what else to say. It's really well done. She understands the role of reason, how it liberates reason, how reason is our tool of survival, and she focuses on that, and how freedom is the condition for the operation of reason. She just covers that so very well. Rights aren't, a right to stuff, because stuff is produced by somebody else. The rights can't, that inherently puts people's rights in conflict. Properly understood, they're not. What they are is, I respect your freedom to act on your judgment, and rights are, if you respect my freedom to act on my judgment. And everybody gains, reason is maximized. The use of reason in society is maximized because it is our tool of survival. And
is that your pooch or mine?
It's my pooch.
All right. Okay.
I'm afraid it's my pooch.
No, it's okay. You don't have to go sick. Don't worry about it. I just wanted to know if it was
mark on disappear because of the dog. So
no. Don't do that. No, we have enough of that. Yeah, I thought her explanation of the role of the mind and rights was phenomenal. There was one point that because I'm insane, that I would differ slightly. She said that a right is not a claim, but a right actually is a claim, just not in the way in which she was saying it wasn't. A right is a claim on others to leave you the hell alone.
It's a negative.
Exactly. Yes.
Let me thread the needle there between the two of you. It's not a claim to stuff or action or your property, no, or anybody else's. What rights are is a claim merely to be left alone, to not coerce me and let me act on my judgment, just as I gain and will respect. For that reason, I will respect your claim to being left alone and not coerced.
Yeah, it's also a claim to me. Whenever I think of rights, Jim, and we can argue about this if you want, because you're just like, it's just like I put Mark in the chair over here, with somebody that just wants to argue for the sake of arguing, even when he's obviously wrong. But when I boil the idea of rights really down and I strip everything away, to me, what it comes down to is rights define when it is moral to use force, and that is in self-defense only. That is, there's no moral sanction for me to initiate force against anybody, but if somebody does so against me, I am perfectly morally justified in responding in kind.
That's a really good way of looking at it. Rights define when force is morally available to be used. Only in self-defense or defense of others. That is to say, only in response to its initiation by someone else. And that's the key. That's absolutely the key. And so what we want to do with rights is create the social condition for the operation of reason. If I point a gun at you, what I've done is effectively made your use of reason ineffective. Yes. I've shut down the use of and if it's from the government, then if government, the more regulation in government, more governmental initiation of force, the more we circumscribe the use of reason in society. So I gain less from your rational faculty if a gun is pointed at you by the government. And so I oppose government pointing guns at anybody. I want to make use of Steve Jobs' brilliance or your brilliance. And that requires that you and Steve Jobs be free to act on your own judgment and tell me freely what your judgment is. How else on earth am I going to take advantage truly of the conditions of society unless each of us is free? So it's a moral prescription on when force can be legitimately used. That's an outstanding way of looking at it. What we're attempting to do is make all adult human action voluntary, uncoerced. And if we can render human interaction voluntary to that extent, we maximize the use of reason in society. Does that make sense?
It perfectly makes sense. Now, Diego says, I agree with Ayn Rand. Rights are not claims. Using claims in the way you gentlemen are seems off. You guys are talking about the Declaration or something along those lines. No, actually, a right literally, as defined going back at least to Samuel Johnson, is a moral claim to something. Or I'm too loud, Michael. Can you turn my volume? You guys are going to drive me crazy with this volume stuff. I got to tell you the truth. I'll turn it down a little bit. That's it. I'm not editing it anymore. So,
well, I'm not going to get into semantics.
No, I want to, because I have
okay.
Right now. Don't pull a mark on me. Now, so the claim, a right is literally a just claim or a moral claim. It's what I am morally entitled to. And what I am morally entitled to ultimately is freedom of action. That I have the freedom of thought, the freedom to put my thought into action. I don't have a claim on other stuff. To say you have a claim on something means that you can get it, or you have a right to it. Not a right, because that'd be just defining by in circularity. But to have a claim means that you can go and get something justly. The thing that you can justly get is freedom of action. You do have a claim. You don't have a claim to other people's stuff.
Yeah.
Or their time, effort, intelligence.
Well, let's look at it the other way. Does that other person have a claim to their own property? Something
Yes.
they created and made. So in a common sense use of the term claim, I could say, and in a legal context, because, I'm a former lawyer. So I would say that a person who owns private property has every right to claim the exclusive use of his or her property. And so in that common sense way, my property, I have a claim to. My peace from being coerced is, in a sense, something I also have a claim to. The danger of using the term claim, and let me be specific about this, is that it sounds like, well, Jesus, I've got a claim to decent housing, medical care, right, or whatever else.
Okay. So now that we've gotten into the weeds and probably lost half the audience. This is what happened, folks. Let me just tell you. So Jim is a fellow insomniac. So it's 2 a.m. this morning, and Jim sends me a text, "Are you there?" And I said, yes. So we ended up talking, and one of the things we were talking about was the whole Tulsi Gabbard intelligence dump, where she's releasing all this stuff. And, so Jim and I argued a little bit about this. So what I did when I hung up with Jim, this was about 3:30. I said, well, I got to get to reading, because otherwise I'm not going to have any stuff to send you. So, okay, so I'm going to get rid of this asshole right now. Existence University, let me just tell you, I'm gonna put it out there for everybody that's listening. This is a vile creature. He's clearly has some sort of personality disorder. Go watch his show and you will see. And if you think I'm defaming you, Existence University, please sue me, because I would love to depose you myself to demonstrate exactly who and what you are. So that's what I'm saying for everybody. So now I'm going to mute him because he's just going to interrupt the show. He is what is called a troll. I've offered to
look like I'm on death's door.
Who gives a damn what he says? I've offered to debate him. I've offered to debate him. Let me give you some background here. This guy chimed in on an interview I did 2 years ago. He came in highly critical. I sent him an email and I said, listen, why don't you and I debate the issues over which we disagree? That's simple. Well, let's do that. He comes back and says, no, I don't want to debate. He says, I'll tell you what to do. I will never mention you again as long as you don't mention me. Okay, deal. Move forward a couple years. He starts commenting on my stuff again. He doesn't like that I interviewed criminal justice, a therapist on criminal change, that sort of thing. He chimes in on that. He chimes in on Jim. But ultimately, first, he refused to debate because he's a coward. Secondly, he comes in with ad hominem attacks and refuses to defend them, and he doesn't keep his word. So that is the reason that I am going to block him right now, just so everybody knows. And then we can move on and get to some actual good discussion. Okay. So Jim and I are arguing 3:30 in the morning. And so what I did was I went and I read all of the released documents that Tulsi released, and I sent those to Jim. I downloaded the entire intelligence report, of which I did not read the whole thing because much of it was redundant and, quite frankly, well, if I couldn't sleep, maybe that's what I should do. That thing.
Sleeping pill.
But I did scan it for the relevant stuff that we're talking about, the Steele dossier, Russian hacking, that sort of thing. I read, I'd say probably half of it in total. I sent that to Jim. I sent the other stuff to Jim. I also went into Grok and asked Grok some questions about the interference, about investigations, and I sent all that to Jim. Okay, so now that we're there, Jim, what do you think about Tulsi Gabbard's dump and the claims that Obama and company are guilty of treason and should be charged?
Well, I'm not there in terms of guilty of treason. Treason is defined in the Constitution as taking up arms against the United States. It's the only crime defined in the Constitution, and it requires that you take up arms against the United States or materially assist someone who does. And we are a long way from treason. And the way Trump supporters use the term treason is irresponsible in my mind. So let's just get rid of that right now.
Okay.
Should the folks who these really dubious folks who work for Obama's intelligence and FBI and use the FBI and the Justice Department in an overtly political way in both clearing Hillary and I think in pushing the Steele dossier. I mean, the CIA said, there's this evidence of Russian interference in the election. It still didn't connect it to Trump. They didn't take the Steele dossier seriously. The folks over at Justice, they continue to use it even tangentially or partially or whatever. But they didn't really have any real evidence of Trump's involvement. And that's what the Mueller investigation showed. And there seems to have been a kind of turn at some point in 2016 in terms of this attitude. I do think people were surprised. Some people were surprised that Hillary lost to Trump. And there's no question that, let me put it this way. It seems to me that I don't have specific information about Obama's involvement, but it does seem to me that in getting the independent counsel appointed in the first place, they didn't have any real substantive evidence of Trump's involvement with Russia. And that's what would trigger a special counsel investigation. And as it turned out, they didn't. And these are the same intelligence folks, of course, who told us the Hunter laptop was Russian disinformation. So I know that Obama's intelligence people were political hacks. I think that's been demonstrated in other ways. I also know that James Comey, the head of the FBI, was totally irresponsible and political in the way he handled the Hillary investigation. And it was the FBI that was pushing back, saying we should still use the Steele dossier. And what everybody seemed to lack, and which I think it deserves some, investigation. What the hell evidence did they have of the Trump administration using it? There's ambiguous intelligence. I mean, it's certainly true that Russia wanted to put out that we wanted Trump to win. Let's put it that way. There was the hacking of the DNC, and what that involved is also a matter of intense controversy. But there were leaks of DNC information, and Putin said, "Hey, I want Trump." So they certainly wanted the perception that they were for Trump, but there's also ambiguous evidence on that. We now know that from our intelligence that they thought, what was the term? Trump is mercurial, Hillary is more reliable. So I don't know what the Russians wanted. I think that there's evidence on both sides of that. But I think it was an effort to, I do believe there was a political effort. At least there's some evidence that there was a political effort to get this special counsel appointed so that it could trip up the Trump administration from the outset. And Obama may well have been involved in that. I would not put it past Obama. So should there be deeper investigation into this? Yes. Now, those people who say Tulsi Gabbard is doing this to deflect from the Epstein thing, maybe, I don't know, but it really doesn't matter to me. The question is, was there sort of a turn in the way they were emphasizing the intelligence reports? Because the CIA had ambiguous intelligence on Russia's intention. Now, did Russia hack any computers that changed the voting? No, that was never shown. But did Russia run campaign ads, from bogus accounts on social media in America? Yeah, I think that's also true. So, I have been intensely critical of Trump since at least 2016. And I think, for example, that the mishandling of classified documents is there, and he lied about it. I think that the FBI was also pretty harsh in doing a search warrant raid at Mar-a-Lago when they didn't do the same with Biden. And Biden got cleared because the special counsel in that case said, he's just a doddering old idiot. And that was, of course, attacked, even though it turned out that, of course, Biden was a doddering, idiot and aging very badly. So I think there's a lot to say. And Hillary, as far as I'm concerned, it was just a political. She had her friends. She destroyed evidence. She was destroying her phone. Her server was at her home.
Okay. I got a question for you, Jim.
Yeah.
Are you familiar with the idea of introducing stuff that's not in question or that's not pertinent to the discussion at hand from your days as a prosecutor?
Well, yeah, I guess.
Okay. I know somebody's going to put a clip out where I'm laughing maniacally. So I was accused, I think yesterday, by Mark. Mark says that whenever I debate Jim Valliant buries me, or he said something along these lines.
Well,
so
intermittent judgment.
Yeah, well, no, this is the thing: is Jim and Mark, I'm convinced, are speaking of collusion. They collude. I think that they had a discussion about this probably beforehand, and it ended with Jim texting me at 2 in the morning to say, "Hey, let's talk. Let's figure this out."
That is a pure conspiracy theory. I had private communication with Mark Pellegrino yesterday or last night.
So
let's put that rumor.
And I think that Mark claimed that he had an audition all of a sudden today that came up at the last minute. I think he sent you to do his bidding. So
no, I can put the kibosh on that. I didn't even know about his audition. All I know is that yesterday. Are
you familiar with plausible deniability?
Plausible, but I have not been in recent communication in the last 24 hours with Mark Pellegrino. So let me just put the kibosh on that.
Okay.
Completely unsubstantiated.
Okay. So let me state at the outset, before I completely dismantle Jim's argument. Let me state at the outset. This is what we can stipulate for the record. I have zero trust for the United States intelligence community, for the Justice Department, for the FBI, or for the President of the United States. I don't trust government. I'd actually probably get on the wrong side of a lot of objectivists, given the degree to which my views are libertarian. That said, I agree with Jim, but that Hillary should have been charged. But to say that Comey, it was entirely political, I don't know that passes the smell test, because it could be argued that Comey ultimately cost her the election by coming out and making a statement about how they're reopening the investigation. So what shows to me is that perhaps Comey is a bit sloppy, maybe a bit incompetent, and using Hanlon's razor, never ascribed to malice, that which can be explained by incompetence. I'm inclined to say that. Now, here's where
political hacks at the judge.
They are political hacks. You're never going to get me to deny that.
Okay.
You are right. Right. So that's true. They're political hacks, no question. But the fundamental claim here that was made by Tulsi Gabbard is this. Before the election, they said that Russia was not attempting and did not hack into the voter rolls. They didn't alter voter counts. Then after the election, what they said was Russia interfered in the election. Those are not the same things. They're not the same claims. They always said Russia was interfering. Yes. They never said that Russia altered voter counts.
That's true.
What they did say is Russia hacked the DNC, whatever it was, server, website.
And that is kind of true. So
that is true. Now, then there's this. A lot of this is commentary on the part of Tulsi Gabbard, or who's ever writing the thing, and she's making commentary about stuff that's not actually in those intelligence documents. One, for instance, she says that, well, look, there was an intelligence leak to the Washington Post that said they intervened on behalf of Trump. Now, this is true that there was this leak, that it is true that after the election, they did start saying they intervened and they wanted Trump to win. That's true. They did say that. But her citing two leaks where you have no indication of who leaked it is not grounds for criminal charges against anybody. You don't even have a defendant to charge.
No, but we later learned from Matt Taibbi and other people that there was also internal, even before this. That's why it's not really new news right now, as far as I can see, that there was ambiguous intelligence that they had at the time about who they wanted to win. But I think it was clear who they wanted us to perceive that they wanted to win. But you're right. Every fact you just stated there is correct. So
okay.
I don't know how we're going to disagree.
No, we're not. But let me put
it this way: putting political spin on it more than anything else.
That's my point. Now, it's also true that I think I want to say 2018, the House committee said that yes, there was interference on the part of the Russians in the election. They refused to say, though, that they interfered on behalf of Trump. But in 2020, I think, or maybe it was 2018, I've been up since 2:30. But the Senate, also controlled by Republicans, said that they did indeed interfere on behalf of Trump. They came to the same conclusions basically as the intelligence. Now, Akira Felix says that we cannot trust Mueller, Comey, or anything. No, I don't trust any of them. My point is that my point here is the claim, and I also don't trust Tulsi, especially not when Tulsi's all of a sudden opening up these files of Martin Luther King and this one in the wake of not opening up the Epstein stuff. It's highly suspicious. And her commentary, what I'm saying, just simply does not fit what actually is there. There's nothing that really changed before and after, except for they now said that they were interfering on behalf of Trump. But intelligence can change. You can learn new things. There's no evidence of this collusion on the part of the intelligence with Obama. There's no evidence of that at all.
Well,
doesn't mean it didn't happen. I'm talking about proving a court of law.
I think that even at the time, back in 2016 and early 2017, I was suspicious because there were meetings with intelligence people at the White House. Now, that's not evidence of much of anything, but it was shortly after that they really made the push for it. Now, there's no question that both the House and the Senate found that there was Russian interference, and the Senate made it really clear they were running social media, but this is what it consisted of: running social media ads
and hacking the DNC
and having a role in hacking in some way the DNC. That's true, and they released it through WikiLeaks and all of that. But that hasn't changed. And fundamentally what you're saying is we already have the basic information.
Yes, but that's my basic point. Is nothing's new.
Basically putting a spin on mostly what we already know.
Yeah. And by the way, they had the Russians attempting to interfere going back to like 2005 5, I think.
Exactly. They've been doing it for years.
They did say they ramped it up here, but what I found interesting, Jim, and this isn't something that, it's not a debate point, but they actually said the Russians held back, that they didn't use their full capabilities to interfere, which I thought was an interesting point. Not that it's even relevant ultimately to what, this issue, but I did find it interesting.
Right. And as I say, we have two sort of ambiguous intelligence from 2016 on this very matter. We think Trump is mercurial and can't be trusted. Hillary is probably more trustworthy, alongside the more available intelligence that said Putin wants Trump to win. And so it's ambiguous. It really is. And it's hard for me to know. It may just be that Russia is testing the waters on how they can influence the election. But I don't think that social media ads made the difference in 2016. In fact, if anything, Comey's suspicious clearing of Hillary may have been more involved. So there were all kinds of things that were involved at the time.
Jim, I got a question, and this is going to be, if you get this wrong, it's fine, because I may be getting it wrong. It's based on memory from almost 10 years ago.
Yeah.
But it seems to me that at the time of the election, that the Obama administration, they weren't emphasizing Russian interference because they didn't want to sow doubt about the election before people voted. Weren't they saying that at the time or shortly thereafter?
I think they were de-emphasizing it right before the election. This is like a 9-year-old memory.
Yeah.
And so if memory serves, they were actually de-emphasizing it as we approach the election.
Okay. Now that I've soundly defeated James in this debate, and Mark Pellegrino is at home with his tail between his legs, running around pretending he's going to an audition, we can move on. Yeah, it's funny how we suddenly agree after I make my case. And I think that Robert Naser's in the audience, and I want Robert to bear witness. Robert is a very important figure in this, because it was actually Robert's wonderful wife, Amy, that put me in touch with Jim Valliant to begin with years ago. Now that I think, maybe Robert and Amy were in on the conspiracy. There's just no telling how far this thing goes. No, it's true.
If you've caught us. You've unmasked the vast conspiracy. The sweet Nasers, who are some of the sweetest, most wonderful, kindest people in the world, were involved in a sinister conspiracy to connect you with me so that Mark and I could get into a secret conspiracy to, gang up on you. Yeah.
Yes.
You got it, Mike.
And you know what? Come to think of it now, I think Rosie Ginsburg, with all his billions, is behind this whole thing.
His billions.
He probably funded this. And remember now, the William Swig
would love to have billions.
William Swig, who everybody knows, William Swig. This guy's credibility. I mean, come on, this is no one could ever question this guy's credibility. He said that your entire point in doing the Leonard Peikoff interview was to deceive me. So maybe that's what this is really, really about.
That's what it was all about. Yes,
it's all the gaslighting of Liebowitz.
I know your integrity. And I know how careful you've been to talk about this. So I was really barking up the wrong tree if I was trying to deceive you. I mean, You respect my honesty and stuff.
I absolutely do.
I can't get you to believe stuff, evidence you don't have access to. And we both said so at the time. I respect your integrity too, sir. And I would never demand that you take a public side on something you don't have personal knowledge.
I have to throw the glove now. I have just received what I think is the biggest insult that could possibly occur. And sir, we may have to duel if you, want to meet me. And what the hell? Now I can't remember. I screwed up the whole joke. Because I can't remember where the duel took place in New Jersey between Hamilton and Burr.
Either, but
I can't believe this. I remember this all the time. Now I can't remember it. Yeah. Either way. I keep wanting to say Sandy Hook, but it clearly wasn't Sandy Hook. He says Mike is slowly becoming Dave Smith and Tucker, just asking questions.
No
way. Okay.
That's really unfair. Yeah.
Weehawken. That's where it was. Weehawken, New Jersey. That's where the duel took. Eutychus, you can meet me in Weehawken, New Jersey, and we can settle this. And just so you know what kind of shifty folks you're dealing with, Jim and Mark are actually going to side with me on this thing. And then it's going to really get ugly. It's all part of their conspiracy.
We will be your seconds. You can meet him at dawn. Mark and I will both be your seconds.
Okay. This Epstein files interrupted thing that I sent. Mike Johnson evidently is going to stop Congress so that they can't get to the bill to release the Epstein files. What say you, sir? What do you think about this?
Well, people can talk conspiracy, and it's weird how people talk conspiracy theories. But first of all, we know Epstein was a creepy pervert who did horrible crimes. We know his wife was involved in that. There were probably other people involved in that, but to go much beyond that is really, really just conspiracy theory stuff and stuff that is tenuous evidence at best. Now, it may also be the case, hey, you folks out there who think that there may have been famous people who are being covered up, it may be for investigative purposes that they're not releasing this information. And, one credible way of looking at it is the Justice Department wants to deflect our attention on this. That's just as credible in my mind as anything else. So when people look, folks, when we don't know, the epistemologically responsible thing to say is, I don't know. Okay? And
exactly.
How about we say, I don't really know? And how about we say, we wait until there's evidence? Could they deep six the information for nefarious reasons? Would that be an arbitrary problem? I guess it's this side of arbitrary, but it's also just this side of arbitrary that they're doing it for further criminal investigations and they want to misdirect us. So my answer is, I don't know. There's maybe a bare possibility of one thing or another, but when it's a bare possibility, I don't go around making public pronouncements.
That's one of the big problems.
One way or another.
Now, I agree with Jim 100%. This is where Jim is at his best, and he's absolutely right. And I know that because he agrees with me. So
the surefire test.
That's my test. But the problem here for the Trump administration and company and the MAGAs is that they've been promoting the idea.
Yeah.
And now when they've actually got the power, they're saying, no, there's nothing to see here.
They made a big deal, didn't they, about releasing the Epstein files and all that.
Yes.
And then all of a sudden it's like, and Bondi, the attorney general, says it's on my desk. Well, all of a sudden, Trump is saying, "What? Are you guys still talking about this, you losers?" Oh, whoa! That was a weird kind of U-turn in the Trump.
Totally weird. Yes.
You see what I'm saying?
I do. And by the way, it's what I think is going to happen with this whole Tulsi Gabbard thing and this intelligence, where she's saying people need to be investigated. None of these people are going to be charged, because there's a big difference between saying something on social media and then having to go into a court of law, which is why, for instance, the Trump lawyers who were out, Giuliani saying the election was stolen, never actually made the claim in a court, because then you have a problem. Now, what's going to end up happening is the people who are...
The problem there is they didn't have evidence.
No.
Neither in Georgia or Arizona or anywhere else they were complaining, as far as I can tell. Now, do shifty things happen? And for years in elections in Detroit, Chicago, Philadelphia, of course shifty things happen.
Not Chicago, Jim. No way.
I'm just naming notorious places where the rumors have been for years that shifty things happen in those places when time for elections. Does that prove anything, though? No. It certainly doesn't prove it changed the outcome of the election.
No. So, now, what will be, Jim, the conclusion of MAGAverse? When no one gets charged, they're not going to conclude that it was all BS. They're going to conclude that there's a cover-up. They're going to say that they're not going to say, you know what, these people shouldn't have been arrested. They're going to say, yes, they should. And here's the thing. Again, I'm not saying they're not corrupt. I believe it. But me thinking that they're corrupt is not enough to go in front of a jury and prove beyond a reasonable doubt that they've actually committed crimes.
Not even close to that. You need to discount every other reasonable possibility based on evidence to win a criminal case in court. And but that's even way too far up the scale. So far, we don't even have probable cause on any of that. So my point is, folks, until we have articulable probable cause, you really not start pointing fingers and making conspiracy. And the thing is, it's a cover up. Of course, when the evidence doesn't materialize, what you do is you create a truly arbitrary proposition. They're covering it up. So the conspiracy theory on conspiracy theory on conspiracy theory can go back and forth, and it gets totally arbitrary as you build this house of cards of arbitrary allegations claiming that there are conspiracy theories on both sides. The Democrats, they were covering it up when Biden was there, the whole Epstein thing. And now Trump is there. Well, Trump, he knew Epstein. So that's the reason why they're covering it up. Good God, people, can you just take a chill pill and realize that you can't make claims without evidence? And until there is even probable cause that something happened, you stop making public pronouncements. My God, that's totally irresponsible.
As an intro to our next topic, I'll tell you, when I was going to trial, we were doing voir dire, and there was a potential juror who was an engineer. And my lawyer said, we want to get him on the jury. And I didn't know. I said, why? She says, because engineers are meticulous. In what they expect as proof. And it makes sense because you're building a bridge. You can't afford to think, well, this might work, or, this probably is going to work. You have to know it's going to work. So
the prosecutor, I liked engineers. And it may go because there are prosecutors who say just that, and defense attorneys who say that just that. If we want reasonable doubt, we want engineers. I was such a Mr. Facts and Logic kind of guy. I really hit hard, rhetorically speaking, I hit hard on the rational evidence side, the logic side, the logos of rhetoric. And so for me, that was never a problem. And if there were complicated medical issues, I'd want a doctor. But mostly what I wanted on juries were people comfortable making decisions, parents, employers, people who have had to judge other people. There are a lot of, especially young people out there. I don't mean to cast aspersions because there are young people who will come back with guilties. But as a prosecutor, I wanted a verdict. And for that, I wanted people who were comfortable and mature in making decisions about other people, judging other people. And that meant employers, supervisors, parents, people of that kind who were already comfortable coming to judgments one way or another about other human beings. Does that make sense?
It does. And that leads me right into the next topic, which is this guy who killed the 4 college students in Idaho. I remember when this happened. I haven't followed the case, but he got a plea bargain. I don't know how much of a bargain it is, but he pled guilty and he returned. They did away with the death penalty in the case, and he's going to 4 consecutive life sentences. In other words, he's never going to get out. Now, I have a lot of issues with plea bargaining in general. The first of which, let me just tell you this, and then I'm going to let you talk. One of the biggest fucking frauds that takes place, and it happens in every court in the goddamn country every day, criminal court. The defendant stands up, he pleads guilty, and the judge says to him, were you promised anything in return for your guilty plea? The answer is an unequivocal yes. Nobody is getting up there and pleading guilty if they don't know what the result is going to be. They're all promised something, a given amount of time. The judge knows this, the prosecutor knows this, the defense attorney knows this, and the defendant knows this. And it happens every single day, multiple times. So that's just one thing that I hate about the plea bargaining system. But Jim, as a prosecutor, speak first on this plea bargain in particular, and then plea bargains in general.
Well, the reason why I'm trying to get the justification, because it seems to me if you've got the evidence and you've charged someone with something so important that got public notice, you go to trial. Why do you not go to trial? If Idaho has a death penalty, I regard the laws as a prosecutor, I regarded the criminal statutes of my state as my marching orders. If I had a personal moral problem with those laws, I tell my boss, I personally can't do this. But the boss, the elected DA, says, well, then we'll just find another prosecutor because we're going to prosecute this under the laws of the state, whether we agree with it or not, because that's the laws of the state. Idaho has a death penalty. I don't understand why a multiple murder in Idaho, they couldn't find, and obviously they could find a prosecutor who had been willing to do this. And so the justification in this case was, well, he'd waive his rights to appeal, and that would secure the convictions in such a way that it gives closure and security to the conviction. That is partially untrue. In 2019, the Supreme Court had decided that even when you plead guilty and you waive your rights to appeal, you don't really waive all your rights to appeal. What about ineffective assistance of counsel?
Hill v. Lockhart.
I'm not sure that's the case.
It is. Strickland v. Washington was the first case that really gave inmates the right to file for ineffective assistance of counsel. Hill v. Lockhart extended it to guilty pleas.
And I think there's a Garza case from 2019.
That would be a later case. Hill v. Lockhart, I think it's like from the 70s or 80s. It's a very old case.
But generally, you know, what really waives so many of your claims to appeal is that there isn't a jury trial where most of the appellate issues will come up. Unless it is ineffective assistance of counsel in coming to the plea, what you're doing when you don't go to trial and take a plea is you're avoiding all of the giant minefields that a prosecutor has to walk through to avoid appellate errors at a jury trial. And most of the appellate error is going to be found, if it's going to be found, during a jury trial. So simply by pleading guilty, forget the waiver of appellate rights, you're actually waiving most of your chance to appeal simply by not having a jury trial. So the point is that it does avoid a trial. It does secure the conviction. It secures it a little better. He does have some still rights to appeal, even if he tries to waive. You get the defendant. Okay, but my beef with this is he didn't say why. He didn't say how. What I did with plea bargains of cases like this is I would say, I'm only going to let you do this plea bargain if you stand up in court and tell us why and how and detail for the judge what your motives were, how you did it. I don't want to, are you pleading guilty because in fact you're guilty? Yes. Okay. That's basically a little more than that is what the Supreme Court requires for a plea bargain. I would say, no, what I want from this entity who committed 4 murders is I want him to explain to the victims why he did it and how he did it. That was inadequate in this case. I also would be pretty hard charging in a multiple murder case. Why the hell would you do a plea bargain here? I'd rather take the chance, roll the dice with the jury. I'd rather take the chance with appellate possibilities than not have all the facts brought to light and get the most under state law that you can get. And if I had a problem personally with the death penalty, I'd simply tell the boss, find someone else who can do it. But Idaho law permits a death penalty. So now you asked me to talk about plea bargains in general. Okay.
Hold on one second. I want to just say something because you said something interesting. Yeah. You said you have to ask the person if they are in fact guilty. And I'm sure that there are a ton of people who say, what do you mean? Who the hell is going to plead guilty if they're not guilty? Therein lies one of the problems with plea bargaining that you may even get to is this. They can offer you, say they offer you 2 years and you're innocent, but they offer you 2 years. You say no and you go to trial and get found guilty anyway on a crime, say that the maximum is 20. They then give you normally upwards of that 20 years. So if you're a rational person who understands that the justice system is imperfect and you're facing, you can plead guilty and get a 2-year sentence or risk getting 20, you might just say it's not worth rolling the dice.
Yeah, that's the thing. There's a coercive aspect to plea bargains. And, you know, there is a kind of plea bargain that you can do in which they don't really have to admit guilt.
Alfred doctrine.
Yeah, so they're actually avoiding something harsher. I morally have a huge objection to that. We should not be taking pleas from people who aren't willing to say, I did the crime I'm pleading guilty to. That bugs the bejesus out of me, that there can be, you know, these West pleas and stuff, these pleas in which there are no admission of guilt. I'm doing it in effect because there's a gun pointed to my head, the threat of a much greater penalty. In most cases, we don't do that. We insist, and I think they should always insist, that the defendant admit that he committed the crime, not because there's some threat over him. A decent kind of plea bargain is the kind of, look, there wouldn't need to be so many plea bargains if we didn't have the war on drugs, if there weren't criminal statutes that that shouldn't be, and the jams the courts, and so 90% of the cases have to be plea bargained. Okay, that is a bad situation right there. So a lot of the plea bargains are because of that. On the other hand, in many cases, and this is where plea bargaining is a decent thing, we know the evidence. He's almost certainly going to go down on it. We've got DNA or fingerprints, or he had the stolen property in his pocket an hour after the theft. You know, boy, or we got footprints leading right from the crime with his size shoe and a distinctive thing under his shoe that we caught him wearing the shoes he's wearing. We've got him dead to rights, or a taped confession. When the evidence is clear and everyone knows he's going to go down, the defense attorney knows he's going to go down. He can tell his client, look, you're going to go down. And if you don't admit, the judge is going to say, well, there wasn't an early admission of guilt on your part. You made the state go through this. So that's not going to serve you well when it comes time for the judge to do the sentence. And what you get in terms of the sentence, you getting back to what you were saying about promises made, the promises I made were all on the record and in that plea bargain, written down. No other promises, side deals, any other crap like that. He knows what the parameters of the plea deal are. The world knows, the judge knows, I know, everybody knows what the parameters of that plea deal are. And if there's any kind of private shenanigans of side deals, that is totally corrupt. But in cases where we know basically the sentence range, in California, we'd gone to determinate sentencing when I was prosecutor. So you had a lower, middle, and upper term, and then the allegations you can tack on. So what we'd do is we'd say you can avoid the upper term, which you do risk, if or we can, in effect, give concurrent sentences when there's more than one crime. But we basically will give you the middle of the line, the midterm, and guarantee that for you because we all know you're going to go down. Now, when it's that straightforward, then a plea bargain is perfectly okay. Everybody really knew what was going to happen. And all we're doing is assuring him of the outcome and, in effect, guaranteeing him something like the midterm because he's admitting up front his guilt. Does that make sense? To me, that is a legitimate plea bargain.
I'll tell you two experiences I had with plea bargaining. In one case, they had offered. I had court cases in three different courts. So I had already been through a whole lot of whatever. My lawyer screwed up royally, but I ended up, I had a 33-year sentence already, 27 of which I was in the process of appealing. And now I had cases in another court. They had originally offered me 9 months. Now, once I got the other 27 years, I went to that court and they offered me 8 years concurrent. And I said, well, what do you mean 8 years? You offered me 9 months. And the judge said, well, you're doing all this other time. What do you care? I said, because I don't want to take this 8 years and then I win appeals and now I'm stuck with this 8 years. And what the judge told me was, look, if you take, he said, I'm not going to let you plead guilty to anything unless you plead guilty to everything. And if you take all these cases to trial, you beat every single one of them but one, I'm maxing you out on that and I'm running it consecutive.
Ooh.
Right? So
that's the coercive aspect.
Exactly. But what ended up, the way it played out was the judge said to me, what the hell exactly did he say? He said, Mr. Liebowitz, I don't understand why, if you're doing all this time, you won't take this 8 years. And I said, well, that's what I want to know. I'm doing all this time anyway. Why all of a sudden did the time go from 9 months to 8 years? And I told the judge, the reason is obvious because the prosecutor wants an 8-year sentence on his, in his record. That's the only reason. And he thinks he can get it easily now because I'm doing the other time. Wow. But the point of the matter is it's like you said, it's coercive. It's not the right way to go about these things.
I agree. When it seems to me that is a clear case of pointing a gun to someone's head and saying, or else we'll do something worse than you would have normally gotten if you don't do it our way. And that's different than giving someone a benefit for an early admission and a true outright admission of guilt. where everybody basically knows the evidence and what the probable outcomes could be, and just giving both sides certainty as to the outcome. That is not necessarily coercive. But in the context that you just described, that's coercion. What you're doing there is saying, do this or else, Mr. Defendant, and that is simply unfair. And our criminal courts are so jammed that really a case like that should have gone to trial. Okay, we should play it out, and in my view. And does that mean that an asshole judge could do what he wanted to do to you? Yeah, maybe, but at least the prosecutor has not put a gun to your head to force a plea.
You know something else, Jim, and you'll be familiar with this dynamic too. This doesn't have to do with plea bargain. It actually has to do with going to trial. When you go to trial and you lose trial, they give you an opportunity. They say, defendant, would you like to say something? Now, I very stupidly was 21 and angry, and I got up and just mother effed everybody in the courtroom. But
that's not going to be helpful.
No, that wasn't helpful at all. But I see a lot of cases where somebody won't speak. In the press, they're buried for it. He didn't speak. He didn't say anything. Sometimes the prosecutor argue it, but they know damn well the defense attorney tells the client, do not say anything.
That's the first thing a lawyer will tell.
Yeah, because if you speak here in your sentencing and then you win an appeal, they're going to hold this against you when you're sentenced. So if you stand up, for instance, after losing a trial and you say, I just want to apologize. Now you win an appeal. They have you basically a confession on record. Okay, the last part of this, and this will be our last, well, no, it won't be our last. There's one more thing I want to ask you about. But Trump wants the judge to compel this guy to give his reasons for why he, why he did the crime. Why the president of the United States is involved in this is absolutely absurd to me.
Executives stay the hell out and let the justice system work it out. Now, the Fifth Amendment to the Constitution, as you know, gives us a right against self-incrimination. What it says is that no accused shall be compelled to be a witness against himself. Now, you can interpret that in various ways. And we reached the point with Miranda and so forth where we've interpreted that in a very strict way. And as a prosecutor, when it came to the evidence, the guilt phase with the jury, I could not even obliquely refer to his silence. If I had told the jury something like, well, if he's so innocent, why doesn't he get up and tell us, that's a mistrial? Or if the judge let me get away with it, that's an automatic appeal, you're out. A prosecutor cannot use a defendant's silence as proof of his guilt. Now, that is not the same thing as giving someone credit for admitting guilt at an early stage. And that can be a part of a sentencing consideration. Did he admit his guilt at an early stage, or we would have to go through a jury and the jury had to come back in 10 minutes and say he's guilty with overwhelming evidence that the judge saw for him or herself? That is a different context. Now, in the case of Kohberger, if I was going to grant guarantee him he doesn't get the death penalty, but gets 4 consecutive life sentences. Look, there were 4 people murdered. There's 8 parents here. 3 of the 8 parents do not want this plea bargain. That would be enough for me to say, okay, screw it. Well, let's go to trial by itself. But if we are going to do a plea bargain, there's nothing wrong with asking him, as a condition of the plea bargain, to detail how and why he did it.
But that would be before he pleads guilty, not afterwards.
That's correct. So if you want, but the contract would bind the prosecutor. If he did so, then we do that. I took pleas like that on more than one occasion. And so using an early admission of guilt in someone's favor or not at sentencing is, I think, conceptually different than compelling someone to be a witness against himself under the Fifth Amendment. And there we have very strict rules. Even when I'm talking to the press, I know I have a taped confession from someone. Before trial, it would be prosecutorial misconduct for me to tell reporters, we have a signed confession or a taped confession. That means what we're doing is we're using that against him. That's how strict the rules are in terms of the guilt phase, the evidence phase before the jury. A prosecutor cannot in any way use the defendant's silence against him. They can't even use it as an argument. You might think it's a common sense argument. Look, if he's innocent, why didn't he say so? He just said, no, I'm standing on my Fifth Amendment rights. I can't use that against him as any kind of logical inference for the jury. I can't even obliquely refer to his silence, or it's prosecutorial misconduct and an instant mistrial.
Okay, last question before you have to give the capitalist thought of the day. The elephant in the room, Jim, that I haven't mentioned yet is the battle that you've been waging on behalf of Leonard Peikoff. You've been fighting for him, for his rights. And over the last couple of days, there's been tapes released online that, were recorded of Dr. Peikoff and his daughter having a discussion. If you don't want to tell us, you don't have to. I'm just curious what your thoughts are on the leaked tapes.
Well, I knew of the existence of this tape and the battle that I've been waging. In effect,
you mentioned it when I interviewed you on the subject.
Yeah, exactly. Since Kira announced the dismissal of her conservatorship case, I had been predicting that she would have to dismiss it because Leonard had made me privy to the evidence in the case. She simply did not have enough evidence to win a conservatorship case. And it wasn't magical prescience on my part to know that. But since she did this, she's been saying I did it to spare Daddy's feelings. And of course, the way she dismissed it by saying, I still have a strong case. I'm considering my legal options. She told the Atlantic magazine, she loves that Atlantic magazine article, which was a smear of Ayn Rand and her father's legacy, frankly. She basically admitted that she was still planning on suing his estate, which was Leonard's fear, which you can now hear in these tapes. Now, I did not think that the tapes should be released until Leonard gave the clearance for it, but they were released. And but it does give people insight into the situation long before we were there. For example, Kira is still relying on this Tanya witness who was a disgruntled, fired nurse caregiver. You see, they used nurse caregivers when Leonard needs that, other than Grace. But in any case, Tanya was not nursing. She did not have a license to nurse. They found out this later, and Tanya was the one who was found to have, been a bad nurse on several scores, financially abusing them because she didn't tell them the truth about having a license to nurse in the first place. And she didn't just call Kira out of the blue. She already knew what Kira was already up to, with or without Tanya's evidence, you see. So I think there's a lot of important evidence before I ever came on the scene. Kira in her letter says, maybe it's Jim who put into your mind that it's money that I'm after. Well, when this tape was made, it was made long before I was ever on the scene. And Leonard Peikoff says, you mean money? And he's getting angry about it because he had given her millions. And she had been causing his life hell. And she is still relying on really awful allegations made by this truly irresponsible person, in my view, unfounded allegations. Grace herself was cleared by 2 Adult Protective Services investigations, one of them based on this Tanya's allegations. Tanya herself was found to have given both negligent care and to have been financially abusive because she lied about even having a nursing license that she claimed to have. She didn't have a driver's license, and she was a disgruntled, fired employee. So Kira can't imagine why that person could possibly be telling a lie, and why this person would have called her out of the blue when everyone knew what she was already up to and trying to undermine everybody's confidence in Leonard's competence. So I think there's a lot of evidence that's very important out there. I don't mind talking about that. I think it does confirm a lot of what Leonard has told me about the matter, and you can hear it for yourself at least. I want to address something real quickly. First of all, somebody asked they want to listen to the recording. Scott Schiff posted it under the name Rich Brilliant. That's his X handle. You can find that. So Ian Gilmore says this, and Ian, I got to confess, I would have been on your side with your position earlier on. And you said we shouldn't even be talking about this stuff. It's gross. The problem with that perspective is that it's very, very public.
And the problem is that it affects, if it was a personal family matter that affected nobody but Leonard Peikoff and his daughter, and it was kept that way, then I would agree. The problem is you had a situation where one person was trying to set up a conservatorship over another person, and then that person, feeling helpless, appealed to the public for help, meaning Leonard Peikoff appealed to the public for help. That puts it out into the public domain. That's the first thing. But also,
well, what put it in the public domain was Kira filing a public lawsuit.
Yes, no, what I mean by public, I'm talking, but I'm talking about the
public.
Yeah, that's true, but I'm talking social media.
Asking for help.
Yeah, I'm talking about the social media.
Filing a public lawsuit.
Yes, that's
true.
It
was filed, mind you, almost exactly a month after this last phone call that you're the recording of.
But I'm talking social media, Jim. I'm not talking about I'm talking about to put it into the social media sphere. So now you have the situation where the facts are very muddled. People are wondering what's happening, but it doesn't just affect them, because the legacy of Ayn Rand is at stake here, depending on who ends up with the copyrights. So it's not just a personal thing. Ian, you say it's public because people keep talking about it, but people keep talking about it because it's an important issue that was
Kira has been on a public relations tirade since October of last year.
Yes, so I
respond to it. And besides, contributing to a legal defense fund only means you want the guy to get a legal defense.
Yes.
You don't have to take a side on the matter.
I have an answer here to this question, and I very publicly have stated that I have not taken sides in this case. Jim knows from my personal discussions, he'll verify that I've told him. I respect him. I believe he's telling the truth, but it doesn't mean he's infallible. I've always said he could be mistaken, and given that I don't have firsthand knowledge, I don't know. But Ann M. has a question. Who deserves to name the group in control of the rights to Ayn Rand's fiction? This is very simple to me. Unless and until it is proven that Leonard Peikoff does not have his cognitive capacities, he is the one that owns them. He is the one that gets to decide, even if I disagree with how he does it. They are his property. And you can't just go out there and say he's old. You have to actually prove in a court of law that he is not competent to make that decision. And nobody, as of yet, has done that. Therefore, Leonard Peikoff is the one that needs to make that decision.
Leonard Peikoff, it's his property and his decision. No one is entitled to it. No one is stealing the family inheritance. No one is owed their father or their grandfather's property. No one has a moral obligation. Even if I tell you for years that you're going to get an inheritance from me, that is irrelevant if the will is valid. And what the validity of a will hinges on, as you point out, is the competence of the person who does the will. And there's all kinds of copious evidence that Leonard Peikoff is competent. I did interviews with him last year. You can judge for yourself. Go listen to those interviews. There are 2 neurological reports. One, he passed 30 out of 30 factors, aced it. The other one, he passed 27 out of 30 factors. Even after being up all night and in pain with an eye injury, it was 27 out of 30 factors. The second neurologist himself said it is clear that Leonard Peikoff does not have dementia. Now, in that report, he said he was mildly to moderately subject to undue influence, but interviewing him, he absolutely denies that anything was done against his will. But that's not directly relevant to his competence either. We're all, to some degree, subject to, quote, undue influence.
Right. Like I'm gonna influence you in a second. But Akira Felix says family inheritance is one of the grossest things I've heard said from family members. I agree. I was very much taken aback from
Leonard,
that.
It's the owner of the property. He can give it to anyone he wants in his judgment, so long as he's competent. It's his property.
Right. And none of us has to agree with it.
And situations can change. None of us has to agree with him. We can disagree with his judgment, but it's his call to make. It's his property, and no one has a claim to it. And circumstances change. So you need those TV commercials. I promise you, nephew, you'll get this car when I get this. That doesn't count. If it's a valid will, any extraneous evidence is even irrelevant of your prior testimonial intentions. Yeah.
Capitalist thought of the day.
Well, I got to get back to Xenia and her marvelous treatment of rights. Capitalism is the system of individual rights. and individual rights are not claims to other people's stuff or action on other people's parts. That is a claim to, in effect, partially or completely enslaving some other person. Rights and slavery are inconsistent. Rights are a logical unity, as I've said before. Rights are simply a recognition of the fact that reason is humanity's, each of us, each human being's basic tool, most fundamental tool of survival. And if I don't have a right to act on my reason, so long as I do not interfere with your equal right to voluntarily interact with people, act on your own reason, then everyone is hurt. Capitalism is the only benevolent system because it allows each of us to live the life we choose to live based on our best judgment. It enacts the ability for us to act on reason, which is our fundamental tool of survival. And I want to recommend Xenia's article to everybody. It is really a well-written article. You can, quibble about semantically the worst of the use of the word claim.
No, it's a great article. Fabulous
It's a stupendous article that makes a really accessible, understandable, and powerful argument for individual rights. And capitalism is uniquely the system of individual rights. Because the minute you start going down the socialist path, what you're saying is that the government or the community has a right to partially or completely enslave a person or steal the fruits of their labor. And that is not capitalism. The huge advances that human beings have made in recent centuries, unprecedented in human history, and in the 200 or 300,000 years human beings have been on this planet, utterly unprecedented. Why? Because we liberated the human mind.
Awesome, Jim. Thank you so much. Well said. And remember, we will be here 23 hours from now to get at this again. And remember, like this episode, share it from YouTube to your social media, subscribe if you haven't, tell your friends about it, do all that. And Jim, where can they find you before I let you go?
Well, I hate to advertise a competing podcast, but people probably already know this.
Here we go. Here's the infiltration, folks. Pay close attention to the money involved.
This is the conspiracy. Razi had nothing to do with me saying this. I just want to say that you can find me over at the Ayn Rand Center UK doing podcasts there. And if you're a paid member over there, a subscriber, you'll get access to seminars I've been doing for years now on Leonard Peikoff's taped lecture courses, essays, and written work. But it's available. And this October, there is sort of for the objectivist world, an unprecedented kind of objectivist conference going on. And I will be giving coaching there for anyone who is interested in going and anyone interested in getting a life coaching on me, because I've had real issues in my life, believe it or not, years ago, and I had to change the purpose of my life. And I have a lot of wisdom to share from that experience.
We're going to do an interview about that coming up, Jim and I.
Very good.
I've just decided.
Okay. But
and by the way, I love Razi. Razi's great. Friend of mine. He's fantastic.
And he didn't put me up to this, believe me. But you can find me otherwise at Facebook. I'm there answering questions almost every day. James Stevens Valliant.
Awesome. All right. Remember, till tomorrow, check your premises in honor of Mark Pellegrino. Goodbye.
Bye-bye.